Hi guys, it's Kathy. I hope you're doing well. Okay, so we made it to day 16 a.m. We actually only have three videos left because I'll tell you why. Day 16 a.m., what we're doing right now is a 2.5 hour video. Day 16 p.m. is a 2.5 hour video. But day 17 is a short video in the a.m., a short video in the p.m., like 20 minutes, I don't know, each. And then the verdict, which is also about 20 minutes, I think. So we only really have two more long videos to go until we hit the end. We are so close. Thank you so much for watching the Kelly trial with me. Thank you. I really do hope that the closing statements are as good as the opening, because the opening statements are the whole reason why I did this. The opening statements were so good. I thought the whole trial was going to be so good. But anyway, let's get working.
We're missing. Oh, yeah. There you go. Thank you. Okay. Ms. Larkin, is Ms. Lothrop in the building? All right, thank you. Here she comes. All right, good morning. We're back on the record in case number CR 2023-026 State versus George Allen Kelly. The jury is absent. All counsel and defendant are present. The court sent a final draft of proposed final jury instructions to the parties last night. I did get an email that was forwarded to me from the state with certain suggested corrections or additions, and let's go through theirs. But was there anything, let's start first with the state. First of all, did you get the email from?
I did,
All right.
yes.
And other than what the state is proposing, and of course I'll hear from you as to that, but does the defense have any additions or corrections to the proposed final draft?
No, I didn't, Your Honor.
All right, so let's go through the state's comments starting, was it page 25?
Yes, Your Honor.
All right, I haven't really had a chance to,
There were just a few typos. The first three,
let me get there. All right, 25, under the definition of intent inference.
I did also send the verdict forms. Did you get those, Judge, that you requested?
No, not yet, but thanks. But we've
One
got some
thing at
time
a
to work on
time.
that. All right, so what's missing here? Intentionally or with intent to as,
Just it should say it need not be established. They're just typos.
Oh.
But the one that's important is really the page 30, justification and defense of premises.
One at
We're
a
missing an
time.
or in that one. That's really critical to the definition itself.
I don't, oh, 31, page 31?
Page 30, defense of
there.
premises.
Let me take a look at that.
Yeah, but defensive premises is page 31.
Yeah, court's page 30 on the latest finals.
Mine's on page 31.
Maybe, I don't know, maybe they printed me the wrong final instructions. Let me look at the court's version.
This is what I got from
Yeah,
Jose.
it's on page 30. All right.
For me, it's on page 31, so I don't know if I have the same copy as everybody.
Did you get the one we sent out
That's the
last
one I'm
night after
looking at.
5? Let's
Let me go
Yeah,
in
I
my
have the right
email.
one printed.
give Ms. Larkin a copy of what you have right there. Jose? Yeah, Ms. Larkin. Make sure she got this. All right, so she's president use of force.
Yeah, that's strange. I don't know. I know.
Thank you.
So you're saying it should say defendant in lawful possession or control of the premises is justified in threat to use deadly force or in using physical force?
Yes.
What did it originally say?
Where are we?
We're on justification defense of premises on page 30.
She puts that we're looking here compared. She had it on
I'm just trying to find it here where it is.
Do you see that, Jose?
It's threatening to use deadly physical force. Threatening to use.
On page 30, justification in defense of premises. A defendant in lawful possession or control of the premises is justified in threatening to use deadly force, or there should be an or in using physical force.
Yeah, okay. I see that.
And then it should say, or in attempting to use physical
Or
force.
in attempting.
They're all highlighted in yellow and in red in my emails, Your Honor,
All right.
to Jose.
Do you see that? All right, now, we can either just either write that in on all the copies to go to the jurors or run off another page of this. Why don't you make those corrections, okay? And run off another page of this, and we'll discuss the other objections or suggestions that the state have in the meantime, okay? And then we'll just rip this page out and put a new page 30 in. All right, is there any objection to that change from the state, from the
No,
defense?
Judge.
Sorry. All right, you understand what I'm saying? Okay, all right, so you work on that. Don't worry about whatever else we're discussing right now until I tell you that there's something else to do. Okay, so we're working on that typographical correction, but in the meantime, we'll go on the record, all right, with the court reporter. All right, we're now on the record with the court reporter in CR 2023-026 State versus Kelly. As I've said, counsel and defendant are present. Beginning with yesterday afternoon and into the late afternoon, the court had an informal jury instruction conference with counsel and the defendant present. We had extensive discussions about the jury instructions, and the court has now prepared a final set of jury instructions. I've made the corrections to some typographical errors and words that were missing with respect to the instruction on page 30, which is defense justification in defense of premises. We're going to make those changes to add the word or, and in changing the word attempted to attempting as suggested. Now, does the state wish to make an additional record as to the final instructions?
Yes, Your
On the
Honor.
record.
Yes, Your Honor. First of all, the state emailed the suggested changes to the court's JAA and to defense last night. I have copies of those. I'd like to make them part of the record, but the corrections are to the definition of intent, inference, the definition of recklessly, reckless disregard, the definition of justification for self-defense on page 26. On page 30, the instruction regarding justification in self-defense, which the court has just indicated that you are making that correction. In addition, the state has requested an edit to the criminal trespass instruction to delete or in a fenced residential yard from that instruction. The reason for that request, and also to remove the definition of fenced residential yard, the reason for that request is that in the justification for defense of premises, the only covered premises is a residence. And so for that reason, the state believes that this portion of criminal trespass is irrelevant and would be misleading to the jury. So the state is asking that that be removed. In addition, the state requests an additional instruction for disorderly conduct with a deadly weapon. And that is because of the portion of the instruction the court is proposing to offer that indicates a person does not have to retreat, except they do have a duty to retreat if they're engaged in illegal activity. It's the state's position that when Mr. Kelly discharged his weapon, he was engaging in disorderly conduct with a deadly weapon, and that would negate his lack of a duty to retreat. Finally, Your Honor, the state emailed this morning, well, and not finally, I do have some other instructions I want to talk about. But so with respect to instruction number 1 on the duty of jury, the state requests the Raji on that and objects to the court's changes. Then with respect to the justification defenses, oh, I'm sorry, let's start first with court's instruction on page 19, evidence for a limited purpose. The state believes that based on what occurred during the trial, 2 statements are necessary in addition to the paragraph that the court proposes in number 19. The state's suggesting that the court add, during the trial, the court allowed questioning of Detective Rodriguez regarding a prior statement of witness Daniel Ramirez for a limited purpose. Testimony regarding the prior statement of Daniel Ramirez was admitted only for the limited purpose of challenging the adequacy of the state's investigation. The prior statement of Daniel Ramirez offered through the testimony of Detective Rodriguez may be considered solely for that limited purpose and may not be considered for any other purpose. Similarly, during the trial, the court allowed questioning of several witnesses regarding a prior statement of an individual calling himself Miguel and of an individual named Ramon Aron Felix Gonzalez for a limited purpose. Testimony regarding the prior statements of Miguel and Ramon were admitted only for the limited purpose of challenging the adequacy of the state's investigation. The prior statements of Miguel and Ramon offered through the testimony of those witnesses may be considered solely for that limited purpose and may not be considered for any other purpose. I have those in writing, Your Honor, and I would ask to submit them to the court. The reason that the state is asking for those instructions is that the court did not instruct specifically with respect to Detective Rodriguez at the time, and whether the state requested it at that time is irrelevant. The state's entitled to the instruction, and we're asking for that instruction now. In addition, the state asked to submit the entirety of the statements pursuant to Escalante Orozco and the Prazer-Fong case, and the state has been prejudiced by the fact that the entire statements were not allowed in. So at a minimum, the state is asking that the court provide this limited purpose instruction with respect to those statements in this case. With respect to the justification defenses, let me make sure I didn't miss anything. And Your Honor, the state believes that without these specific limited purpose instructions, the state will be prejudiced. We believe that it's confusing to the jury what the purpose of allowing those statements were, particularly without the context of the entire statements that the state asked to offer in this case. And so for that reason, the state believes that the specific evidence for limited purpose instructions as to those 3 statements is critical and necessary to the state's case. Next, Your Honor, with respect to the court's proposed justification defenses instructions. First, the state's overall objection to all of the 5 instructions on justification defenses proposed by the court is that they are duplicative, that they place undue emphasis on these defenses because they are so duplicative and repetitive, and they are confusing in the way that they are presented. Starting first with page 26 and the justification use of physical force instruction, that instruction is completely contained in the justification for self-defense instruction, which is beneath it. So it is completely duplicative. There is no purpose for adding that instruction twice, except to unduly emphasize the defenses. Next, Your Honor, with respect to the self-defense, use of deadly force in self-defense, that instruction is appropriate. However, the instruction regarding self-defense, use of physical force is not appropriate because there are no facts in this case that were elicited during this trial that even offer a scintilla of evidence that there was physical force used in this case. There is only the use of deadly force. Next, Your Honor, defense of a third person, that instruction is offered at page 29. And that instruction also
Why is he letting her do this one at a time? Just do one at a time.
lacks any physical or any factual basis during this trial. There's no evidence in this case at all to support an instruction for a defense of third persons. Mrs. Kelly was inside the residence at all times. There was only one shot that was ever even alleged by any party, and that only party that ever offered any evidence regarding another shot was Mr. Kelly. The circumstances under which it were offered do not support a defense of third person instruction. Next, Your Honor, there is a defense of premises instruction. And pursuant to State versus Hussain, Hussain, 189 Arizona, 336, the defense of premises instruction, when the self-defense instructions and the defense of third person instructions have already been offered, makes the defense of premises instructions duplicative and unnecessary. In addition, Your Honor, I want to add with respect to defense of third persons that the State versus Level case 97 Arizona 269, which has been a case that's been around since 1965, indicates that that is not appropriate for the facts of this case. Also, Your Honor, the state believes that the instruction justification in defense of premises is inadequate in this case because in a opinion that the state is offering solely pursuant to the Supreme Court rule that allows you to cite to unpublished opinions, it's the State versus Button case 2019 Westlaw 439823 at paragraph 4, defense of premises is limited and a person may only use deadly force in the defense of himself or a third person. The way that this instruction is written does not make that clear, that the only time you get to use defense of premises as a defense is if you're defending yourself or a third person. That's why the Hussain case says that this instruction, when you've already offered the other two instructions, is completely duplicative and unnecessary. And the state believes that that prejudices the state by the duplication of the same instructions over and over and over again in this case. May I just have a second to look around and make sure I didn't leave anything out? Anything I missed? Your Honor, and I would offer our written emails and requested corrections to be made as part of the record, including what I just read into the record with respect to the limited purpose instruction.
Can you go get Jose, please? I'm sorry. You finished?
Yes,
All right, thank you very much. Yeah, you can make that, those will be filed and made part of the court record.
thank you.
You can give those to the clerk right now. What is the defense position about the objections, suggestions, and corrections that are proposed by the state?
That are contained in the email. I guess I'll start there. I'm okay with the typos that they're pointing out. They are requesting that they delete or in a fenced residential yard.
Do you just tell me the areas, if there are any, of agreement with them
Okay.
And we'll start from there. How about that?
Sure. Their first item is page 25. There's a typo on intent inference. I'm okay with making that change. Then also on page
And
25.
which one was that? Intentionally with intent to?
Intent inference, Your Honor.
Oh, it need not be established by censor. There's an it meaning missing?
Yes.
Okay.
Yes. Then page 25, definition of recklessly or reckless disregard.
What's the correction there?
They say the risk must be of such a nature and degree that disregarding it is a gross deviation. So the risk must be, instead of a such nature, of such a nature, and degree that disregarding it is a gross deviation.
Okay. All right. Jose's already made that correction.
Okay.
All right. And he made the other one too.
All right. Page 26, there's a typo in justification for self-defense, number 1. A reasonable person in the situation would have believed that physical force was immediately instead of immediate.
Okay. He made that correction.
All right. And then I think the one on page 30 was already made as well.
Right.
So on page 30, criminal trespass, the state is requesting that the court cross out or in a fenced residential yard. I don't know why they would cross that out. According to Mr. Kelly and Wanda, they saw individuals who were running in the paddock area, which is immediately adjacent to their residence and is fenced.
All right.
And that-
I'm asking for your areas of agreement with them to start.
Okay, okay.
But I understand what you're doing, but just,
Okay, I'm just trying to go in order. Do you want me to skip over the things I disagree with and just go to the things we agree with? Okay.
Correct.
In which case, that is it.
all right. So the bailiff, my judicial assistant, has made those corrections to pages 25, 26, and 23 and 30. So he's running off copies of those pages so that the pages that need to be corrected can be removed. We'll insert those pages, and then we'll have a full set of instructions for each of the jurors. Should just take a few minutes. Other than that, the state's requests are noted for the record and are all denied.
Your Honor, can my client and I share a actual copy of the new revised?
Right, he's running off a bunch of copies,
Okay,
so
wonderful.
hopefully there should be enough for everyone, but yes. All right, so we'll get that copied off, we'll get those pages substituted in, and we'll be ready to bring in the jury and do final jury instructions and
Go,
begin closing
Judge.
arguments.
You go.
We don't want to do the verdict forms, Judge?
I'm going to be working on that. We don't need the verdict form until we discharge the jury to go and start the deliberating, so I'll be working on that during the closing arguments. But
Okay.
if you emailed it to him or give it to the judicial assistant, and
Yeah, I have
he'll pass it
multiple
up to me.
copies.
And I did some research on that last night as well.
Okay.
All right, so, well, here he is.
Oh, Your Honor, I did have a record to make.
Hold on,
with
hold on one
respect to that,
second.
too.
Hold on one second. So how are we doing? What are we doing now? All right, do you have somebody to help you? Just, yeah. Yeah, because what do you have, like 20 copies of them, right?
Yeah.
All right. Yes, go ahead.
The record I had to make on that is that the defense requested that the jury make the determination of dangerous nature during the aggravation phase of the trial. We didn't object to that, and I just want to make sure that if there's any issue with respect to that, it's waived by the defense, because I did not include that in the verdict forms for that specific reason. If that issue is not waived by the defense, we'll need to add that back in, the interrogatory with respect to dangerous offense.
All right.
It looks like everybody came a day too early. They came for jury instructions. Look how full it is though.
As you folks talk about that amongst yourselves while we're just finishing these, getting these instructions prepared, and then,
Would you like the verdict form?
yes, I would.
She was gonna cry if you didn't take that piece of paper.
All right, thanks. Well, they're working on that, folks, so hopefully it'll just be a few minutes. We'll be able to get going. Be in recess until we have the jury instructions ready to go.
Please rise.
Okay, all right, maybe this is gonna be a quicker video. No, no, this is the closing arguments. This won't be quick. Oh, that was really quick, really short. I'm trying to see if this is closing. It looks like it is closing, right?
Thank you. You can be seated. All right, what we're going to do, we're back on the record. Everyone's present except the jury. What we're going to do is we'll prepare a set of final instructions that'll go to the jury that have those corrections on pages 25, 26, and 30. But as I read them, I'll make the corrections orally and inform the jury what it should say on those particular pages. Let me just make sure I have that written in. But the final instructions will be a corrected set of instructions. And that'll save time. All right, so 25, intent inference should say it need not be, right? And then on, let's see, what was the correction on 26 again? 26.
The other 25 was under recklessly, Your Honor. And it's the second sentence. The risk must be of such a nature and degree that disregarding it is a gross deviation.
Recklessly means the defendant is aware of and consciously disregards a substantial and justifiable risk. The risk must be of such a nature, right? All right.
And then 26, did you want that one?
Yeah, what's 26?
It's under the justification for self-defense. And instead of immediate on number 1, in the second sentence, it should say immediately.
All right. And then 30. Right, or in attempting. All right, very well. All right, let's pass out the final and jury instructions, give them to counsel and the defendant, and put one on each of the jurors' chairs. Thank you.
That one, no. Oh, yeah. Sure. I don't need to see. Hey, Jorge. Can we flip the screen so he can see it when he's
I
presenting?
haven't, thanks.
Can we turn it? So that he can see it when he's presenting?
Can you rotate that screen?
So he can see it? We just didn't want to ruin your technology.
All right, let's bring in the jury.
That's okay. Share the screen.
She is always the last to stand up. It's just rude. Stand up.
Have you checked to make sure it's not presented? Did you try it? Can we test the screen, Valeria? Can we test his screen?
Oh, sure.
Who's going to do the closings for the defense? All right.
I'm just so excited we're getting to the closings. This is awesome.
have on your screen onto the gallery and this?
I will be, yes.
Okay. Yes, sir. I know, I'm just trying to get something better than that. Yes. Is that what you're ordering?
You're a smart person. You can figure it out.
Please rise.
Thank you. Please be seated. The record will show the presence of all the jurors, counsel, and the defendant. Ladies and gentlemen of the jury, thank you for your patience. Obviously, my projections yesterday about how long this would take us didn't turn out to be accurate. So thank you for your patience. But we are now ready to proceed with the final jury instructions. Each of you has a copy of the final and jury instructions. There's a couple of typographical errors that I'll point out, I think, as we go along. You're welcome to follow in the instructions as I read aloud or just listen to what I have to say, whatever you're most comfortable with. You will have one set of these final jury instructions with you in the jury room when you are excused to deliberate. So you'll have a set of these as well. All right, so the first page is a cover sheet with the caption of the case. Page 2 is where we start. It's called Duty of Jury. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide the case. It is your duty to determine what the facts are in the case. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as the jurors, are the sole judges of the facts. You must consider all of these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think that the defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means the state must prove each element of the charges beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. We should be on the top of page 5. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means that the state must prove each element of each charge beyond a reasonable doubt. In civil cases, this is not, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. There are 3 standards of proof that we use in our legal system. 1, preponderance of the evidence. 2, clear and convincing evidence. And 3,
Sunlight, guys. There's sunlight.
beyond a reasonable doubt. Preponderance of the evidence is a party having the burden of proof by a preponderance of the evidence must persuade you by the evidence that the claim or fact is more probable true than not true. This means that the evidence that favors a party outweighs the opposing evidence. Clear and convincing evidence, a party having the burden of proof by clear and convincing evidence must persuade you by the evidence that a fact or a claim is highly probable. The standard is higher than the standard for proof beyond. The standard is higher than the standard for proof by a preponderance of the evidence, but it is lower than the standard for proof beyond a reasonable doubt. Now we come to the standard in this case, which is proof beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means that the state must prove each element of each charge beyond a reasonable doubt. Proof beyond a reasonable doubt is proof by the evidence that leaves you firmly convinced of the defendant's guilt. This standard is higher than the standard for either proof by a preponderance of the evidence or by proof by clear and convincing evidence. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. You must decide whether the defendant is guilty or not guilty by determining what the facts are in the case and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. You are to determine what the facts in the case are from the evidence produced in court. If an objection to a question was sustained, you must disregard the question, and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. The state must prove guilt beyond a reasonable doubt based upon the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. In their opening statements and in their closing arguments, the lawyers have and will talk to you about the law and the evidence. What the lawyers say is not evidence, but it may help you to understand the law and the evidence. Some of the exhibits that have been admitted into evidence have portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to decide the importance to be given to the evidence regardless of whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness has testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before the trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of all of the other evidence. Consider all of the evidence in the light of your reason, common sense, and your experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. you are to consider the testimony of a police officer just as you would the testimony of any other witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all of the other evidence in this case. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant, acting with the advice of an attorney. You must not let this choice affect your deliberations in any way. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. You have heard evidence that a witness has previously been convicted of a criminal defense. You may consider this evidence only as it may affect the witness's believability. During the trial, the court admitted evidence for certain limited purposes. In connection with that evidence, the court gave you limiting instructions. That evidence was admitted only for the limited purpose that the court stated at the time, and therefore you must consider it only for that limited purpose and not for any other purpose. Evidence of other acts that have not been charged has been presented. You may consider these acts only if you find that the state has proved by clear and convincing evidence that the defendant committed these acts. You may consider these acts to establish the defendant's preparation. You must not consider these acts to determine the defendant's character or a character trait and therefore committed the charged offense. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proved beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdicts. The crime charged of second-degree murder requires proof of one of the following. One, the defendant intentionally caused the death of Gabrielle Quen Butamea, thereafter abbreviated as GCB. Or two, the defendant caused the death of GCB by conduct which the defendant knew would cause death or serious physical injury. Or three, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The crime of second-degree murder, which I just described, includes the lesser offense of manslaughter and the lesser offense of negligent homicide. So now we're going to discuss the elements of the offense of those two additional lesser included offenses. Manslaughter. You may consider the lesser offense of manslaughter if either, one, you find the defendant not guilty of second-degree murder, or after a full and careful consideration of the facts, you cannot agree on whether to find the defendant guilty or not guilty of second-degree murder. Reckless manslaughter requires proof that the defendant recklessly caused the death of another person. Reckless manslaughter, the crime of manslaughter, requires proof that the defendant caused the death of another person and was aware of and showed a conscious disregard of a substantial and unjustifiable risk of death. The risk must be such that disregarding it was a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Second-degree murder and manslaughter may both result from recklessness. The difference is that the culpable recklessness involved in manslaughter is less than the culpable recklessness involved in second-degree murder. We should be at the top of page 24. If you determine that the defendant is guilty of either second-degree murder or manslaughter, but you have a reasonable doubt as to which it was, you must find the defendant guilty of manslaughter. You must unanimously agree that the state has proven manslaughter beyond a reasonable doubt before you may find the defendant guilty of manslaughter. The other lesser included offense is negligent homicide. Negligent homicide. You may consider the lesser offense of negligent homicide if either, one, you find the defendant not guilty of second-degree murder and not guilty of manslaughter, or after a full and careful deliberation of the facts, you cannot agree on whether to find the defendant guilty or not guilty of second-degree murder or manslaughter. The crime of negligent homicide requires proof that the defendant, one, caused the death of another person, and two, failed to recognize a substantial and unjustifiable risk of causing the death of another person. The risk must be of such a nature and degree that the failure to perceive it is a gross deviation from what a reasonable person would observe in the situation. The distinction between manslaughter and negligent homicide is this. For manslaughter, the defendant must have been aware of a substantial risk and consciously disregarded that risk that his conduct would cause death. Negligent homicide only requires that the defendant failed to recognize the risk. If you determine that the defendant is guilty of either manslaughter or negligent homicide, but you have a reasonable doubt as to which it was, you must find the defendant guilty of negligent homicide. You cannot find the defendant guilty of any lesser included offense unless you find the state has proved each element of the lesser included offense beyond a reasonable doubt. Now we go to, I think it's count 2 of the information, the second charge, which is aggravated assault. The crime of aggravated assault requires proof of the following. One, that the defendant committed an assault on Daniel Ramirez. And two, the assault was aggravated by the following factor, that the defendant used a deadly weapon or dangerous instrument during the assault. Now, the definition of assault is as follows. The crime of assault requires the proof that the defendant intentionally placed Daniel Ramirez in reasonable apprehension of imminent physical injury. Now we have some definitions of some of the terms used in defining the elements of the offense. Knowingly. Knowingly means that a defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known that the conduct is forbidden by law. Intentionally or with intent to, as used in these instructions, means that a defendant's objective is to cause the results or to engage in that conduct. Intent and an inference, intent may be inferred from all the facts and circumstances disclosed by the evidence. there should be a word it, and your final instructions will read, it need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Recklessly or reckless disregard means that a defendant is aware of and consciously disregards a substantial and unjustifiable risk that the conduct will result in death. The risk must be of such a nature and degree that disregarding it is a gross deviation from what a reasonable person would do in that situation. Physical force means force used upon or directed towards the body of another person, and this includes confinement, but does not include deadly physical force. Physical injury means the impairment of a physical condition. A deadly weapon means anything designed for lethal use, including a firearm. Deadly physical force means either, one, force which is used with the purpose of causing death or serious physical injury, or two, force which is used, or two, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Justification. Use of physical force. A defendant is justified in using physical force as follows. The use or threat of physical force or deadly physical force is justified only while the use or threat of physical force or deadly physical force is justified only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that imminent physical danger appeared to be present.
Immediate physical danger, not imminent.
Okay, thank you. Let me correct that. If I misspoke, I'll start at that paragraph again. Thank you. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. Actual danger is not necessary to justify the use of physical force or deadly physical force. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. A defendant is justified in using or threatening physical force in self-defense if the following two conditions existed. One, a reasonable person in the situation would have believed that physical force was, and that should say immediately necessary, to protect against another's use or apparent attempted or threatened use of unlawful physical force. And two, the defendant used or threatened no more physical force than would have been necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of physical force or deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. Actual danger is not necessary to justify the use of physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that physical force was immediately necessary to protect against another's use or attempted use or threatened use or apparent attempted use or apparent threatened use of unlawful physical force, or you must measure the defendant's belief against what a reasonable person in the situation would have believed. The threat or use of physical force is not justified, 1, in response to verbal provocation alone, 2, to resist an arrest the defendant knew or should have known was being made by a peace officer or by a person acting in a peace officer's presence, or at the peace officer's direction, whether the arrest was lawful or unlawful, unless the physical force used by a peace officer exceeded that allowed by law. Or 3, the defendant provoked the other's use of unlawful physical force, unless the defendant withdrew from the encounter or clearly communicated to the other person the defendant's intent to withdraw, reasonably believing that the defendant could not withdraw from the encounter, and B, the other person nevertheless continued or attempted to use unlawful physical force against the defendant. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. A defendant is justified in using or threatening deadly force in self-defense if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the defendant used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary.
Okay. Everybody needs a break for a second. He can't possibly think the jurors are listening to this. I'm trying really hard to listen to this, but I can't listen to this. So we need a break. We need to shake it off. We need to talk, breathe. We're almost at the end, guys. We're almost at the end. There we go. Let's jump back in.
To defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use or attempted use or threatened use or apparent attempted use or apparent threatened use of unlawful deadly physical force. You must measure the defendant's belief against what a reasonable person in the situation would have believed. A defendant has no duty to retreat before threatening or using deadly physical force in self-defense if the defendant, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in an unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. The state has has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. The next charge concerns the justification for defense of a third person, a different person. A defendant is justified in using or threatening physical force in defense of a third person if the following two conditions existed. One, a reasonable person in the situation would have believed that physical force was necessary to protect another's use or attempted use or apparent attempted use or threatened use of unlawful physical force against a third person. And two, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect another's use or attempted use or apparent attempted use or threatened use of deadly physical force. Defense of a third person justifies the use or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, one, physical force was necessary to protect against another's use or attempted use or apparent attempted use or threatened use of unlawful physical force against a third person, or two, deadly physical force was necessary to protect against another's use, attempted use, or apparent attempted use or threatened use of physical force against a third person. You must measure the defendant's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, you must find the defendant not guilty of the charge. The next charge relates to justification of premises. A defendant in lawful possession or control of the premises is justified in threatening to use deadly physical force, and there it should say, or in using physical force, or in, and it should say, attempting to use physical force, or in threatening to use physical force in defense of premises, if a reasonable person in the situation would have believed it immediately necessary to prevent or terminate the commission or attempted commission of criminal trespass by another person in or upon the premises. The use of force may not be greater than reasonably necessary to prevent the attempted criminal trespass. An actual criminal trespass is not necessary to justify the use of physical force in defense of premises. A defendant is justified in defending premises if the defendant reasonably believed that a criminal trespass was being committed or attempted. You must measure the defendant's belief against what a reasonable person in the situation would have believed. The defense ends when the attempted or actual criminal trespass ends. The state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Now, here's some additional definitions. Criminal trespass is knowingly entering in or remaining unlawfully in or on a residential structure or in a fenced residential yard. Premises means any real property and any structure, movable or immovable, permanent or temporary, adapted for both human residence and lodging, whether occupied or not.
I wish he had a loading button a loading thing right here so we know how far into it we are? I mean, okay, hold on, let's look. We're at 1 hour and 8 minutes. Oh, wait. Okay. All right, hold on. Not that bad. Oh, we're almost done. Look, he's giving his closing argument. Oh, we're about to almost done.
Residential structure means any structure, movable or immovable, permanent or temporary, adapted for both human residence and lodging, whether occupied or not. Fenced residential yard means a unit of real property immediately surrounding or adjacent to a residential structure and enclosed by a fence, wall, building, or similar barrier, or any combination thereof. All right, the final two instructions are instructions I'm going to give you after the closing arguments and when I send you out to deliberate. So that concludes the final instructions. Were there any corrections in the court misread, anything else other than has been pointed out by counsel?
No, not from the state, Your Honor.
No, Your Honor.
All right, very well. So ladies and gentlemen, you put those aside. Again, you'll have corrected with those typographical errors, you'll have corrected the final instructions with you in the jury room when you retire to deliberate. And with that, the state can begin its opening and closing argument. Mr. Jetty.
Thank you, Your Honor. Good morning. This is the first time I've been able to address you directly. Once again, my name is Mike Jetty, and I want to just echo what Ms. Hunley said at the beginning. We appreciate your attentiveness during the entire trial. It's been 4 weeks, so we appreciate the time and devotion you have because it's a very important duty we have here. I'm going to start off by saying that I'm not going to go over every fact. I'm not. My job here is to take the wheat from the chaff here and focus in on the important things in this case. Our goal here is to simplify. So if there's a fact that I didn't cover, don't read into that. You're the deciders of the facts to apply to the law the judge just read. Okay? State v. Kelly. This occurred on January 30th of 2023. Oh, I'm sorry. Was this? The whole thing was not. I'm sorry, Lydia. That's my bad. Like I said, my job here is not to go over every fact in this case. State v. Kelly, it's an event that occurred on January 30th of 2023. Gabriel and Daniel were in the U.S. seeking the American dream. Yes, both were undocumented migrants. Both were escaping extreme poverty. Defendant sees Gabriel and Daniel running back to Mexico, not just running back to Mexico, 115 yards from his property, beyond 2 fence lines. And they're running because earlier they found Border Patrol. The group scattered and the 2 took off. The defendant sees them beyond the 2 fence lines, 115 yards away, picks up his AK-47 that he keeps by the patio door, steps outside of that patio, on that patio door, in the patio area, and without verbal warning, without a shout, without any indication to both Gabriel and Daniel, points that weapon at these 2 men and shoots over and over and over again, 9 times. Gabriel was judged that day and sentenced to death by the defendant. This picture of Gabriel And that's a picture of the AK-47, the weapon used. That weapon can fire 30 rounds in 6 seconds. You were out there. We had a jury review. I forget which week it is now. I think it was last week. And that's a view from the patio and the gravel. And this is 14 months ago. So obviously there's new growth out there. We were all out there. And you see that's an individual out there. This is the side view from the patio and gravel. You saw this picture earlier in opening. And that is Detective Barba out in the distance. Question you have to ask, is that a threat? Is that a threat to you? The answer is no, it's not a threat to the defendant. That's a picture of Gabrielle in the high grass. The lights in the background of the Kelly's home. The position of the body, orientation of the body, the injury matches up directly with the defendant's home. That's the injury wound caused by the projectile, which matches up with the defendant's home. That's a picture rolled over, Gabriel rolled over, hand clenching his chest, I've been shot, falls forward and dies. That injury breaks 3 ribs, perforates the right lung, 3 lobes of the right lung, and severs the aorta. You're not moving after severing the aorta. You're done. Life is over. It's a picture of a drone. We're going to walk through it. Saw the cones. That's estimated by Detective Bunting where the shooter was standing. We're going to go past one fence line. We're going to pass a second fence line. This is a distance here. 115 yards. And we're going to see some red cones here where the victim's body was located. And we all stood out there on that site. Camera's going to pivot. You heard from DPS that they took the drone footage and put it on a mapping of some sort, and it gives us this GPS mapping. The blue line on the left-hand side, that's a north-south directional line. The red one, east and west. And that green line is the patio to the victim's body. And that's the orientation of the victim's body. I'm going to say it again. Matches perfectly from the patio to the victim, the orientation of the body. The defendant shot 9 times. He's been charged second-degree murder and aggravated assault with a deadly weapon. Second-degree murder, you heard from Ms. Hunley in the opening, is a unified offense. There's 3 ways to prove it. You don't have to agree on all 3 ways, but you have to agree on second-degree murder. First way, Kelly intentionally caused Gabriel's death. When you walk out on a patio and point a gun at someone and shoot 9 times, that's intent. Kelly caused Gabriel's death by conduct Kelly knew would cause the death or serious physical injury. An AK-47 is a serious weapon. This ain't no play toy. And when you fire it 9 times at a human being, It's a serious activity. Third, under circumstances manifesting extreme indifference to human life, Kelly recklessly engaged in conduct that created a grave risk of death and thereby caused Gabriel's death. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. Two men walking southbound, no danger to you, and you don't even give a warning? Hey, get off my property. Get off my property. Or just sit back and let them continue on. Facts of this case. Gabriel and Daniel were shot at. Gabriel is dead, killed by a high-powered weapon. An AK-47 is such a weapon. Kelly wound is to the right side back, exit wound to the chest, consistent with the direction of the defendant's home. The defendant's words on his dispatch or BP to dispatch to officers and during Detective Ianza's interview, inconsistent. Every single time the story changed. Every single time the story changed. Daniel's words, consistent. Heard an AK-47, horse saved his life, heading southbound. I just want to repeat real quick since we're on Daniel. Daniel's the only one in this courtroom, on this hill, and likely in the city of Nogales, who's ever been shot at with an AK-47 9 times and be next to a friend who just died. So maybe during his testimony, distance and time is a little skewed. Just maybe. But he knows it's an AK-47. He knows it's a red horse who saved him, and he's heading southbound. Defendant steps out, no verbal warning. Defendant shot his AK-47 9 times. There's shell casings found with the ejection pattern that matches what DPS forensic scientist Burnell is consistent with the ejection patterns and position orientation of the body, once again, matches up with only one known shooter. You've heard instruction, there is also a lesser included. So if you do not find beyond a reasonable doubt the defendant caused second-degree murder, you can consider manslaughter. And manslaughter, as a judge read, and you'll have jury instructions, I won't spend too much time on this, but it requires proof the defendant caused the death of another person and the defendant was aware of and showed a conscious disregard of a substantial and unjustifiable risk of death. Stepping on a patio with an AK-47, shooting at 2 armed men walking southbound, no danger to you. And if you don't find second-degree murder and you don't find manslaughter, you can consider negligent homicide. Negligent homicide requires proof of defendant caused the death of another person. The defendant failed to recognize a substantial and unjustifiable risk of causing the death of another person. Aggravated assault, second charge. Aggravated assault with a deadly weapon. The defendant committed an assault against Daniel, and the defendant used a deadly weapon, an AK-47. Assault requires defendant intentionally puts Daniel in a reasonable apprehension of imminent physical injury. Steps outside with an AK-47 and shoots that gun. And that's the horse. According to Daniel, saved his life. He recognized that horse. He identified that horse. That's the defendant's horse. And that horse was between him and the Kelly's residence. Defendant's words. I'm not admitting to anything I've done, but all those things tend to add up. And they do. We're moving the wheat from the chaff here. Agent Marcel, first witness for the state. 2:30 phone call. I'm going to summarize these for you. First phone call, I'm being shot at. I'm shooting back. There are 5 people, all packs, with packs running southbound. I'm being shot at and I'm shooting back. 5 individuals in this story. That's at 2:30 in the afternoon. 6 minutes later, defendant changes that story. I had an altercation with someone. I heard a gunshot in his direction, in my direction. Inspected his horse while they spoke. I'm gonna argue he inspected his horse because he shot his gun 9 times. He wanted to make sure he didn't shoot his own horse. They were too far to tell if any of them had firearms. And that's probably the most truthful thing he says here. Because you were out there, 115 yards is pretty dang far away to see a firearm on an individual. 2:40, 10 minutes after that first phone call. And what's happening in the background with 2:30 is BP is now communicating to SO Dispatch. And SO Dispatch is doing a code 3 alert and lights and sirens going off, and all SO people are responding to scene because to them, they think it's an active shooter. And we want law enforcement to believe when we call them, we want them to believe the story. They're not here to second guess it. So lights and sirens are going. And 10 minutes after that phone call, respond, active shooter response. You heard testimony. The goal is number 1, preservation of life. BP locates a defendant near his barn. And you heard Agent Heredia on the stand. He appeared calm. 10 minutes after being shots fired, I'm shooting back, the defendant is calm. He's calm. He's carrying an AK-47, walking with his 2 labs. No one located on the property on a security sweep. No one. 3 p.m., defendant says people were possibly carrying rifles. Possibly now. We went from I'm in a shootout to too far to tell, and now maybe not, maybe so. They were 100 to 150 yards away from his property. Castaneda told the defendant that if anything like this happened again, don't do anything, call 911, stay in your house. And his response, understood it. He said, I'm going to do what he had to do to protect his property. He was conscious of the consequences. He would take responsibility for his actions. Talking to BP and SO, the defendant never admits that he shot his AK-47. We've got Border Patrol and agents on scene for an active shooter situation, and you failed to tell them that you shot your own weapon? Never told law enforcement that anyone pointed a gun at him. Didn't tell anyone. This just happened. This literally just happened. And you're not telling a single soul that people are shooting at you? Never told law enforcement he was in fear of his life. 423, he's calling. I think this is a thank you call for Agent Marcel to get a quick response to him. In this call, he says, now, instead of 5 folks, we have 10 to 15, all loaded with AR-style rifles. We're getting exaggerated statement here now. 523. And this is the second wave of phone calls. That was the first wave, the active shooter call. And now we got the calls and dispatch recording related to Gabrielle's body. Jeremy, this is Alan Kelly. You need to call me immediately. This is serious. Call me immediately. I can't say more on the phone. Why can't you say more on the phone? Why can't you say more on the phone? 5:26, he sends that text message. 5:35, here comes the fourth phone call. This is worse than you can imagine. This is bad. Marcel told Kelly, call 911 and talk to SO. He never does. He never calls the SO. The SO calls him because Marcel does what a Border Patrol agent is supposed to do. If there's an immediate emergency, he routes a call to the local law enforcement, which is the SO. And the SO then, without him calling, calls him to find out what's going on, what's so serious, and why immediate response again. You know how shots were fired earlier? Something was possibly struck. Just say, there's a body on my property. Just say it. When Marcel asked for additional details, Kelly said, I can't tell you over the phone. Ask Marcel if this was being reported. That's a noteworthy question right there. This is that dispatch call. Do I have my microphone? Let's see if we play it.
Hello?
Hi, sir. I'm calling from the Santa Cruz County Sheriff's Office.
Yes.
Hi. I'm just calling because we received the report from Border Patrol.
Yes.
So I'm just calling to get more information. So what happened?
You're going to have to send an officer out here.
Okay, what's going on?
I can't.
I'm sorry?
It's very serious, ma'am, and I'm not going to talk over the telephone.
Okay, I understand it's serious, but I need more context in order to send a deputy.
Okay, fine. It's going to be,
Go ahead,
well,
you can talk to me. What's going on?
yeah, I know I can talk to you, but you're responsible for what I say, and I'm responsible for what I say.
Can you give me a little context of what happened? What's going on? You told them that
I'm not
you shot
sure.
at something. What did you shoot at?
I didn't shoot at any. I haven't said I shot at anything.
Okay, well, that's what Border Patrol told us, so that's why I'm just asking you.
Yeah. Y'all guys, the Nogales Sheriff Department had 4 or 5 guys out here this afternoon investigating a Border Patrol drug running incident. And I don't know if I can't remember the officer's name. There was 2 gentlemen and 2 young ladies, and maybe third. You know who I'm talking about? They came out to 100 Willer Cross Circle.
You mean for my deputies, correct?
Yeah, they were Nogales.
Yeah, I'm aware of what happened earlier.
You're aware? Okay, then they're aware of what happened, and I don't want to get you in trouble, and I don't want to get me in trouble, but I don't want to break the law or anything like that. So what I'm telling you is that we need a sheriff deputy out here, 100 Willer Cross Circle, immediately, and that's all I can say, ma'am.
Okay, is anyone hurt? I need to know, because if someone's hurt, I need to send an ambulance too.
There's no.
Okay, do you feel more comfortable talking to a deputy over the phone?
Well, in other words, okay, you know the thing. You have the right to remain silent, and anything you can.
I understand.
Anything you say can and will be held against you in a court of law. I'm not admitting to anything I've done, but all those things tend to add up, and I don't know what happened. I just know what I just saw about 15 minutes ago. and it's something that an ambulance cannot help. EMTs cannot help. There's nothing out here that can be aided by EMT or emergency services.
Okay, I understand you don't want to give me a lot of details, but what you are requesting an officer from me, so I just needed to know for their own safety and your safety a little bit of what's happening, what's going on.
Okay, I'll put it like this. Last spring out here, there was a pickup found on East Sagebrush with a dead lady in it.
Mm-hmm.
I don't know if you knew of that or not.
Yes, sir. I'm aware of what happened.
Okay, it's a situation similar to that. How's that?
Okay.
You follow? You understand what I'm saying?
I
It's a
understand what you're
situation exactly like that.
Okay.
And so that's going to require the sheriff to come out here.
Okay. Can you tell me a description of? Does it
No,
involve a vehicle?
I don't have a description. There's not a vehicle.
Okay.
The only thing that I was referring to in conjunction
Is
with
the
that
incident?
accident was the body.
Okay.
You got it?
Okay. All right.
You
Okay. Can I have your name?
Yes, George Kelly.
George Kelly. Okay, George, if my deputy goes over there, would you take him to whatever it is
Yes,
that you
yes.
found?
Yes, I have it marked. I have a flashlight on over it because it's going to be dark when he gets here probably, but I'll take it to him.
And you are sure an EMT cannot help?
I am positive. I have a medical background. An EMT cannot help.
Okay. Do you know whoever it is that you saw?
No, I do not know. I didn't say it was anybody. I just said it was a body.
Okay. All right. Okay. All right.
I'm not trying to be smart, ma'am. I'm just
I
trying to.
understand. You're trying to be careful, and I get that. However, I hope you understand that on my end, I have to take care of my deputies too. So I
Yes, I
needed a little
understand.
bit more context as to why you needed a deputy to head out there.
Now you know that there is a body here,
Okay. All right. Does it look somewhat?
and it's not alive. So you asked, did you need EMT? I said no.
Okay.
I'm sure a coroner will be involved sooner or later.
I understand. George, can you tell me something? Is it discolored from somewhere?
Is it discolored?
Yes.
What does that mean?
Has it been there for a while? Can you tell?
From what? In that I only approached the body to make sure that the animal, it's not a vegetable or a mineral. The animal wasn't alive, and it was not alive.
Okay.
There were no signs. There was no signs of blood. There was just an animal laying face down.
An animal?
An animal, and you know what an animal is. It's not a vegetable or a mineral.
Okay.
It's a body, and you know what I'm talking
I
about.
understand what you're talking about, George.
Yeah.
Okay. I'm going to send the deputy then over to your house so you can lead them over to wherever you found what it is.
Okay.
You found, okay?
And now, maybe one of the deputies were out here. They know how to get here because it's 100 Willow Cross Circle, and it's kind of hard to find. It's a ranch right on the border. So
I have one of my deputies that responded earlier going over your way.
that's good. You do that. They know how to get here, and I'll have the gate open.
Okay. Sounds good, George. Thank you. Thank you for the
I appreciate your help and your patience, and I'm sorry if
No problem. I understand.
Okay.
Okay.
Bye.
Thank you.
That's a phone call SO had to make to the defendant. Defendant says it's very serious. Recap. Very serious. Can't tell. I'm not going to talk over the telephone. I don't want to get me in trouble. I'm not admitting to anything I've done, but all those things tend to add up. Deputy Lopez gets on scene. That's Exhibit 38. I'm not going to play that for you, but it's admitted into evidence. That's that recording that Deputy Lopez recorded. He says in that, quote, defendant, I have no idea, I have no idea, I have no idea. And you know, if you were me, you got no idea. You know what I'm saying? You literally shot your gun 9 times and you got no idea what possibly could have happened. Sergeant Rodriguez gets on scene, 6:15. Sergeant Rodriguez is the one that pronounces Gabriel dead. That's not the time of death. That's the pronouncement of death by law enforcement. No pulse, extremities are cold, but his torso was still a little warm. Importantly, there's no drag marks, blood trails, or foot traffic evidence anywhere. It appeared as though Gabriel fell where he was shot. And at this point, Sergeant Rodriguez does not know Dr. Tim's autopsy results. A severed aorta. That's a drop shot. You're going down. The entry wound lined up with the east patio of the Kelly residence. Again, entry wound and orientation lines up. And then the defendant has an interview with Detective Ainza. In that question, he says, question, did you shoot? I have no reason to believe I shot this person. Ainza, what does that mean? Defendant, it means I have no reason to believe I shot him. That's simple. Question, did you shoot? No response. No response. Detective Ainza at this stage has already talked to Border Patrol. He's already talked to dispatch. He's already talked to SO. So Detective Ainza has information. And during an interview, he's not going to disclose the information. He wants the defendant to talk to him. Defendant does not say he shot his weapon. And until 30 minutes into this interview, a 50-minute interview, he finally does. And this is the interaction. Look at me. I can see it in your eyes. Defendant, I haven't said I didn't shoot. Did you shoot? No response. Towards these gentlemen. No, I did not shoot at those gentlemen. Did you shoot? All Detective Ainza is trying to figure out is, did you shoot? And finally he says, yes. Then he says, I shot over their heads. Shot over their heads. He shoots in their direction, says that this time, Ainza asks if it's 100, 150 yards away. He affirms that. And he says they were armed. Remember earlier statement, too far to tell? You were out there. I shot 100 yards over their heads. I didn't shoot at them. I shot over their heads. Ainza, you shot towards the direction of their heads? Yes. Does not admit he shot his AK-47 until 30 minutes into that interview. You saw pictures of the shell casings. You're out on scene. Right next to, if I'm on the patio, they're right to my right. 8 shell casings found. And those are the 9 total. 1 in blue found by the ATF canine. Canine alerted the evening of. That's around 12:30 in the morning. And the next day when it's light out, they found the other 8 shell casings in yellow. And the ejection pattern, as we're going to see in a second here, is consistent with the ejection pattern of DPS forensic scientist Brunel's review of that weapon shooting the exact same rounds. Let me get to the AK-47. Where was this gun? Where was this gun that he keeps by the patio door? It was hanging up on a coat rack on a bedroom door behind a sweatshirt. And the only reason it was found was Sergeant Flores opens the door stops his momentum, but the gun continued and bumped the back of the door. He looks behind the door and sees this weapon. What's not true in this case? What's not? There is no evidence of a mysterious shot. None. The only person in this courtroom who's ever said anything about mysterious shot is the defendant. His wife doesn't even say she heard a shot. And you heard when Ms. Hunley had Miss Kelly on the stand, you wonder why we asked the question, what were you watching? I was watching a news show. What was the volume? It was on 20 out of a range of 100. You're in your living room. Your husband's in the kitchen. He hears a gunshot and you don't. And you're watching and listening to news at a medium volume. That's a mysterious, magical gunshot in this case. No evidence that it exists. None. The other one is the boogeyman. We've got a lot of armed men on the property. It went from 5 to 10 to 15, all carrying packs, all with rifles, walking this property. And they changed the number. They changed the distance. They're creating a fear here of the boogeyman being there. There's no evidence. None. We have 2 migrants coming to the U.S., heading back to Mexico, who get shot at. Defendant under fire. No evidence whatsoever. They did a search with a metal detector from the house to the victim, no other shell casings, and from the victim out, no round or other shell casings. None. No damage to the house. If you're being shot at, if you're in your house and you're being shot at, where's the damage to the house? No evidence of drug packs or drugs. No evidence of robbery or theft. No evidence of struggling or dragging. None. Someone else must have shot the victim because the victim stumbled over. This is a severed aorta. You don't stumble around. You heard Dr. Tim. You may take 1 or 2 steps and may utter a gasping phrase or two, and you're done. During voir dire, I think it was mentioned by counsel that this is a shoddy, I'm paraphrasing, this is a shoddy investigation. Here's everyone involved in this investigation. Local law enforcement, we've got Border Patrol agents, we've got DPS, we've got outside experts, medical examiner, we've got a guy from Washington, Mr. Wyatt, we've got Mr. Telsel from the East Coast, and we have the FBI. This is a thorough investigation. This is Agent Douglas, who you heard on the stand testify about downloads from the defendant's cell phone. You saw that? AK getting a lot of work. 33 dealt with this week. AK hot. AK hot again. It's either fight or run, and I'm too old to run. There's BP cameras out there. Anything like this? Expert witness you saw, I mentioned him earlier, DPS forensic scientist Brudenell, talked about the functionality of that AK-47. It works, it's operable. Talked about the ejection pattern, which is consistent with his testing with the results on the scene. Rounds coming out to the right. Doesn't matter if you're right-handed or left-handed. No matter. The projectiles are coming out up right-hand side of the gun. The injury is consistent with a long-range shot. Why do we know that? Well, we have two things we got going on here. We have GSR, we have that cloud from a gun. When you shoot a gun, there's a cloud of particulars that come out. And you heard testimony that usually within 20 feet, some of that cloud dust is going to come on to the person. Well, there is no GSR in this case, which means only other reason is you're further than 20 feet from the victim. That's what it means. This ain't no close range shot, holding a backpack and doing a gangster style shot. That's not what's going on here. Because there would be a cloud. There'd be gun residue all over that person, all over him. There's none. You heard the witnesses. They damped the clothes all around and submitted to Ms. Torsell. You heard testimony. No GSR found, which means further than 20 feet. I think it's easy to say that 115 yards is further than 20 feet. You also heard from DNA and fingerprint analysts from DPS. The reason we did is we're doing a thorough investigation here. We're demonstrating to you, you deserve to know that the government is doing a thorough investigation. That's our job. And there is none. Not surprising. There's only 2 people involved in this case. Or 3, counting Daniel. Rick Wyant, expert from Washington, talk about ballistics, talk about the wound. The bullet used is consistent with the wound. Shooting reconstruction, and he talks about the bullet being in yaw. I call it a wobble. It hit something on its way. It hit something on its path. So instead of being like a nice little spiral, it's like a duck, like someone throwing a duck football. There's a little spiral off. When it hits that body, that's why the entry room's a little off. And you saw the scene, mesquite trees all around, could hit a branch anytime. It was Rick Wyant who asked SO to go cut that branch, just to double check. There's no evidence on the branch, but it's an indication to you all why the bullet is in yaw. It hit something before it hit. And that's why there's no bullet wipe, which means when the bullet's carrying some of that particulates on its way, on its journey, and when it enters the body, it's going to leave what we call a bullet wipe. And there is no bullet wipe in this case because that bullet is in yaw because it hit something before hitting the victim. There's no mystery to that. Ms. Torsell talked about no GSR found. You heard from Dr. Tim, cause and manner of death, homicide, bullet wound. Injury is consistent with an AK type weapon. From collapse to possible step or two, there is no walking with that injury. There is no walking, stumbling around. There is not. And then I just want to talk about the skeleton because that was demonstrative used in this case where defense counsel put the rod, the trajectory rod through the skeleton and said, that must have been the trajectory of that round. That's kind of like a gangster style shooting where you're trying to take the backpack and you're coming up from underneath and you're shooting. But you heard Dr. Tim talk about this and you heard Daniel. Possible reason number 1, when someone shoots a weapon at you, what's your reaction? To duck. And the moment you duck, you line that body up. And second, you heard Dr. Tim say, once it hits that rib cage, it gets deflected inside the body. There's 2 reasons why that is the way it is. Not because there's a robbery, not because there's 5 guys out there trying to take quote unquote drugs off the victim. Entry wound, like I said, in yaw. Exit wound, come out of the body. It's interesting. Had my gun, shot my gun. He says at 2:30 to Border Patrol. Doesn't tell Marcel ever again. She had a couple conversations with Marcel after that. Does not tell him. Does not tell BP Heredia on scene. Had my gun, shot my gun. Does not say that. Does not say to Deputy Monreal on scene. Does not say had my gun, shot my gun. Does not say it. Castaneda on scene. Does not say had my gun, shot my gun. These are officers who are responding to a code 3. This is lights and sirens. This is an emergency. Does not tell Deputy Lopez, had my gun, shot my gun in this event. Does not tell Sergeant Rodriguez, who's the one who pronounced the victim dead, I had my gun and shot my gun. Does not say anything. Nothing. And you wonder why no one's looking for shell casings around the property? Because no one knows, quote, he shot his gun. No one knows that. Because the only person who's talking to Border Patrol is going to be Detective Ainza, and he's here at the station. The defendant never says, had my gun, shot my gun. Never. And Ainza, after 30 minutes, he finally admits, had my gun, shot my gun. Dispatch Supervisor, Miss Huerta. Defense Exhibit JJJ. At 3:05, Border Patrol contacted Wanda Kelly, and Wanda Kelly, according to dispatch, says, my husband's giving chase. Okay. Husband's giving chase. And to their story, there's 5 armed gunmen with AR-style weapons on my property. There's a shootout, and you're going to take your weapon and go chase them. You heard it on the dispatch log. It's Exhibit JJJ. You guys can pull it up. Canines and the defendant and the canines are on scene first. And he says, there's a quote, canines disturbing the scene. Canines are at the body. 6:42, Rodriguez is trying to confirm with Border Patrol the subject struck something. There's no jumping to conclusions. None whatsoever. He's asking for confirmation and he gets confirmation. Deputy Castaneda, this is Wanda's statement when he's on scene. 5 individuals, some carrying rifles. Defendant grabs his rifle, he keeps by the door, not hanging in the bedroom door under a sweatshirt, keeps it by the door. Went outside, heard shots outside. Does not say the shots she heard were the defendant's shots. And then he takes off and leaves her to go chase the marauders. Defendant states that they were running south and pursued. Importantly, Castaneda on scene, no rifles, no backpacks, no signs of a large group of 5 people passing through. None. Agent Marcel, it's important. Agent Marcel told you there's no RIP crews in the past 10 years. No AR-15 rifles ever found in the past 10 years. And if this is being reported, that quote, he said it meant to him, he thought it meant, is this being brushed under the rug? Undocumented migrants, you heard testimony. Migrants, not drug dealers, not gun carrying, toting drug guys, but undocumented migrants coming here to the United States for a better life make up 98% of all apprehensions. 98%. They all wear camo because migrants also don't want to be detected, and they all carry backpacks with food and water. There's no mystery here. 0 because you have a backpack. None. Migrants use radios for pickups. When they come into the country, they're going to get picked up in a car to get transported. Yes, this is all arranged. We're not dummies here. We know how this works. But having a radio does not mean you're a drug dealer. Having a radio means you're communicating with someone so you can get picked up later on the side of the road. So you can be traveled to Tucson or Phoenix or wherever you're going. Defendant was reluctant to have the SO respond. And cartels, when they get involved, they make things messy. There's no single shot with a cartel. None. Daniel, the victim, an eyewitness. From Honduras, extreme poverty.
Counsel,
Yes,
we're
sir.
about due for, I think the jury's been in here since about 9 o'clock, so it's been about an hour and a half. Well, I'm sorry to interrupt you, but
No problem.
we have to take a recess. So we'll take a 20-minute recess. We'll be back here in about 10 to 11. We'll stand in recess until 10:50, 10 to 11.
Please rise, come forward.
He broke up his closing argument. Does he have to do the same to the other side now? Right? All right, let's get through this break. I'm like cutting this so close to me getting to work tonight. So I can't pause. I got to keep going.
Is present, and let's bring in the jurors, please. Defense counsel, have you seen the proposed draft verdict form from the state?
I did, yes, Judge.
Okay, we don't have to talk about it. I just want to we'll talk about it later. Just want to make sure you had it.
Oops, you could tell by I did, Judge, that she doesn't like it.
Please rise.
Please be seated, and the record to show the presence of all the jurors, counsel, and the defendant. And as soon as you're ready, Mr. Jetty, you can continue with your closing argument.
Thank you, Your Honor. We left off with speaking about Daniel, the second victim and the eyewitness to what happened. What Daniel is not, he's not part of a drug organization. He's not. He doesn't work for the cartel. He does not. 6th grade education, and he knew Gabrielle for about a year. There's a picture of him in testimony. I'm talking about consistent statements. AK-47 shot, Red Horse. He also nailed it on how the victim died, clutching his chest, arm up. And that is the picture we see of Gabrielle. They crossed, no weapons or drugs. No one in the group had weapons or drugs. No one. Returned to Mexico, and the shots were fired. These are 2 unarmed migrants heading back to Mexico. Shots coming from the defendant's property. He tells you shots were coming from the right-hand side, and the horse is saving his life. Heard 8 to 10 shots. There were 9 shell casings found. Consistency. And he is scared. Being shot at with an AK-47 is serious. Seeing your friend die in front of you is serious. Grabbed his chest and said, "I'm hit." Agent Heredia, first on scene at 2:40. No people, no tracks, looking for the defendant. Remember, this was an active shooter response. Saw no rifles, no backpacks, no drugs. And defendant was calm. Kelly said, when he met up with him, he said that 5 to 7 people were carrying bundles. He went from 5 people to 10 to 15, back down to 5 to 7. The never mentions with Agent Heredia. Never mentions he said he was shot at. Never mentions he was shot at. Never mentions he saw a weapon. Never mentions a weapon was pointed at him. He's calm. Never mentions he even fired that weapon. It's 10 minutes after this shootout event. Monreal, Miss Kelly saw 5 armed men. Kelly went after them, heard 4 shots. Those are the 4 shots, 4 of the 9 shots by the defendant. The defendant said, this baby is always by the door. And that's an AK-47, which is behind the bedroom door, hanging up on a coat rack behind a sweatshirt. That's the same AK-47 that he always keeps by the door. And he says they were possibly carrying rifles. Officer asked, did the armed men shoot at him? Didn't know what direction they shot. Justification instructions. There's a litany of those in your packet. You got one for use of physical force, one for self-defense, one for use of deadly physical force, defense of a third person, and defense of premises. That's your homework. I'm going to tell you, cheat sheet is always a reasonable person standard. So when you see 2 unarmed migrants walking southbound beyond 2 fence lines, and you take your AK-47, you walk out and don't say a word, point it at them, and you shoot, would that be what a reasonable person would do in that situation? The answer has to be no. The answer has to be no. No evidence of any armed gunmen. No one found on BP footage. No foot traffic. No other shell casings. And they used a metal detector. I think they used up to 3 metal detectors on 2 different days. No other shell casings found. No one heard the mysterious shot, the made-up shot the defendant now claims started this entire event. He has to give you something. The guy give you something to justify why he shoots 9 times at a migrant. He has to give you something. He gives you this, quote, mysterious shot that even his wife does not hear. No evidence of drugs, guns, a struggle, robbery, anything. And when the cartel gets involved, they leave things messy. They also don't leave evidence. No evidence of any rip crew in the area. And you heard Agent Marcel on the stand. Not in the past 10 years. Not in the past 10 years. No justification for stepping on your patio with an AK-47, not giving a warning, and shooting 9 times at 2 men who are southbound away from your property. No justification at all. Reasonable doubt? You got jury instruction on that? I want to talk about is your common sense and experience. We're in this is a magical area we're in. This is what democracy is about, sitting in a jury, listening to a case, and determining the guilt and innocence of an individual. This is what our democracy is about. But you still use your common sense you use in everyday life. You still use it. I'm going to give you an analogy. I think the judge used the analogy for direct and circumstantial evidence with the rain outside. And he told you if you didn't see it, you have no direct evidence of it, but you go outside, there's circumstantial evidence of rain. I want to use the same thing for reasonable doubt. We're sitting inside this courtroom, and you go outside, the facade's all wet, the pavement's all wet, people are carrying umbrellas. You were here all day long for the past 4 weeks, but you're here all day long. You don't hear it rain. You don't see it rain. You don't smell it rain. You don't smell anything. You don't smell the bushes and the wonderful odor. You don't smell any of that. However, is it beyond a reasonable doubt it rained? Yes. Is it possible that a truck came by, a fire truck came by and sprayed the facade and the ground? Yeah, it's possible. That's a ridiculous doubt. Use that same standard here. The same standard. There is no bandits out there threatening the defendant. None. Facts again, Gabriel and Daniel were shot at. Gabriel is dead. Killed by a high-powered weapon, an AK-47. Entry wound, right side, exit wound, chest, lines up perfectly with the defendant's property. We're calling the wheat from the chaff here. Defendant's words, inconsistent. Defendant's words actually were consistent with some of the physical evidence. Shot 9 times. Eventually he says he shot 9 times. And now we have shell casings. Consistent there. And Daniel's words, always consistent with the physical evidence. Steps out, no verbal warning. Defendant shot his AK-47 9 times. Shell casings found. Ejection pattern consistent with what Brunel did on a test of that same weapon with the same rounds. Position and orientation of the body lines up with the defendant's home. I'm going to ask you, I'm going to come back second time, I'm going to find him guilty of second-degree murder. But you also can decide if you're not satisfied with second-degree murder, you can consider manslaughter. If not satisfied with either second-degree murder or manslaughter, you can consider negligent homicide. And find him guilty for aggravated assault with a deadly weapon against Daniel. I'm going to leave you with this. Detective Ianza says in the interview, the moral of the story is you shot and someone is dead. And his answer is yes. That's all I have here.
Thank you. Closing argument from the defense.
That was very sad. That was a very, very sad closing argument.
Good morning. I'm the quiet one. Can you hear me? Okay. If I speak too quietly, just wave at me and I will do something about that, all right? So I just want to start off by telling you this about this case. And it's first in your jury instructions when you go back to review them. They're going to tell you don't guess. You're not supposed to make guesses about what happened in this case, and you're not even supposed to solve the mystery or discover all of the facts that were left out of this case. Don't guess. We have this very high standard in criminal cases. The standard here is proof beyond a reasonable doubt. Not is this questionable, not is this suspicious, not even is this likely, not even is this really darned likely. The standard is proof beyond a reasonable doubt. And I'm going to come back to that standard, but we have that standard for a reason. This is the most serious type of courtroom that we ever get in any kind of case in this country, is a criminal case. And for the most serious type of courtroom, we have the most serious standard of proof. And it's your job as jurors to hold the government to that standard of proof. We don't guess when we're dealing with criminal law. We don't guess when we're dealing with criminal charges. So please don't guess. I'm going to ask you to assess the facts of this case. We have two competing versions of events in this case. We have the state's idea, and the state says that Mr. Kelly walks out of his house one day with no provocation whatsoever. He takes aim at a great distance at people who are unarmed on his property, and he fires shots intending to hit those people. That's their version of events. Mr. Kelly and his wife tell something very, very different. And I'm going to talk about what they say happened here, but I want you to ask yourselves while I'm going through that, is what Mr. Kelly and his wife says consistent with the facts, the known facts of this case, the known evidence that has been presented to you? Not, is this consistent with somebody's subjective interpretation of somebody else's words? Those aren't facts. Those are guesses. I want to ask you if what Mr. Kelly said happened is consistent with the facts. And it is. The evidence has showed that Mr. Kelly comes from Montana with his wife, and they eventually settle here and they begin ranching. The evidence showed you in this case that they had a long time on this ranch before anything, happened. They've been here for decades. They are locals at this point. We heard from Wanda about the increased activity that took place on their property that we talked about in the opening statement. Wanda testified to that. You heard from Mr. Kelly about different instances where he was shot at. When he was interviewed by Detective Ainsa, he described those instances. We heard from Gary Wisdom, one of Mr. Kelly's neighbors who's in that same area, the same thing. When he originally started ranching there, he saw small family groups and didn't feel any danger. Gary Wisdom later says, eventually I started seeing bigger groups of men carrying weapons. And he called Border Patrol to report that at times. Border Patrol came out. He has no idea if they ever caught them or not. We heard from Border Patrol that this is a high trafficked area. There's a lot that comes through here. It's just north of that area where the wall ends. There are people who come through. There are drugs. There are vehicles. We heard from Border Patrol that it's impossible to distinguish nowadays really who's carrying drugs and who are just groups of migrants, because the drugs have gotten smaller as time has gone on. We have heard from Border Patrol that there are things that exist called rip crews. There are bandits. There are people who will rob migrant groups, who will kidnap migrants, who will steal drugs, and who will get into violent altercations with other people who are engaged in criminal activity in this area. That's not Mr. Kelly's imagination. That's what you heard from Border Patrol, who are out there every day on the ground dealing with what goes on out there. Border Patrol also talked about how there are a lot of unknowns. We know the cameras are not that effective. We know people know where to avoid detection. They know how to avoid detection. They know where our cameras are. So there's a lot that goes on that goes unseen and unknown by Border Patrol. They see signs of it. They know it's out there, but they're not able to respond, and they're not able to make apprehensions all the time. And this is what's going on in Mr. Kelly's life during the lead up to this incident on January 30th. The state talks about text messages that Mr. Kelly sends between himself and his friend, Gary Miller, a very close friend who he's known for a very long time. This is somebody who Mr. Kelly trusts and who understands where Mr. Kelly's coming from. Those messages come in that context. Those messages also come in the context of Mr. Kelly receiving continuously information from Jeremy Morsell, the Border Patrol Ranch Liaison. Jeremy Morsell is continuously communicating with Mr. Kelly about large groups on his property. They're nearby. Be careful. We're working a group of this size. It's in your area. It might come your way. They might be carrying narcotics. Narcotics trafficking has picked up around Keno Springs. This is the communication that Mr. Kelly is receiving on a regular basis from Border Patrol. Border Patrol knows what they're talking about. Mr. Kelly relies on that information. The level of fear and concern that Mr. Kelly experiences on his own property is increasing as a result. He chooses to arm himself in case he ever has to defend himself. And he expresses that to his friend, Gary Miller. He talks about the fear. He talks about what's happening on his property. He does it in an over-exaggerated way to help him blow off some steam, to help him feel a little bit better, and to help assuage some of the concerns that he has, because he never knows when something is going to happen. And ultimately, something does happen on January 30th of 2023. Mr. Kelly is in his kitchen eating lunch. It's a day like any other. He's been out about on his ranch. He's planning to do some more chores for the rest of the day. He has no idea that he's about to be in a life or death situation. He doesn't ask for it. He's minding his own business in his own house, when suddenly he sees something. He sees people carrying rifles, carrying backpacks out the kitchen window. He does the right thing. He calls law enforcement. He is not some sort of vigilante who decides he's going to take matters completely into his own hands. He calls for help. He calls the guy who has the badge and the gun. He calls Jeremy Morcell. And he tells him, I hear a shot or there's shooting. I might have to return fire. Immediately, he tells law enforcement that he may have to fire. When he's walking outside, he has heard a shot. This is not a mystery shot, as the state describes. This is a real shot. Mr. Kelly hears it, and the whole situation completely changes in that moment. A gunshot outside of your home is not something you hear every day. And it's not something you hear in the same context with people running with rifles and backpacks across your property. This is a frightening, scary situation. And in frightening, scary situations, people flee, people freeze, or people act. And Mr. Kelly acted. He is being confronted on his own property, in his own house, with criminal activity involving guns in his yard. And he doesn't know what's going to happen next. He knows he needs help, so he calls Border Patrol. But he doesn't know how long it's going to take them to get there. And he doesn't know what these people are going to do in the meantime. The state would have you believe that you have to stay in your house in a situation like that. You do not. The law does not require that you stay inside of your house. In fact, that is not the smart thing to do. Mr. Kelly, when he walks outside with his rifle, his intention is to stop this threat. His intention is to make these people go away. Because if you stay inside your house, you don't know what they are going to do. They're going this direction right now, but after you lose sight of them, who knows where they're going to go? Who knows what they're going to do? This isn't a conscious thought process that Mr. Kelly went through at this time either. This was a split-second decision. He sees a threat, he responds to the threat. Mr. Kelly is the man of his house. His wife is there. He needs to protect himself, and he needs to protect his wife, just like every man should do. And he is 100% justified in walking outside to meet this threat. When he walks outside, he sees people. He sees that they are carrying rifles. He walks out onto his porch. The metal door bangs behind him. It makes a noise. The person in front looks at him and points his rifle at him. Mr. Kelly tells this to Detective Einsa. He points his rifle at me. Under those circumstances, Mr. Kelly is 100% justified in firing his weapon at that person. He doesn't need to fire warning shots. He is justified in firing at that person in that moment. Again, split-second decision. Mr. Kelly doesn't think, now I'm going to fire some warning shots in the hopes that I will have to avoid doing something else. There is no thought process. This is an immediate life or death scenario. It's an immediate decision that Mr. Kelly makes, and he chooses to not take that shot. He chooses not to fire at that person. Instead, he raises his rifle up above the tree in front of him. And you all have seen the tree. You've been to the patio. You know what this looks like. He raises it up. He fires warning shots. As the state said, he could have emptied this magazine. He doesn't. He stops shooting because these people start to run away. He has some more conversations with Agent Morcell about this. These folks are going somewhere. They're gone. The threat is over. He goes out to check on his barn, and he encounters Border Patrol. He has already told Agent Morcell that he was going to fire shots. As far as Mr. Kelly knows, Agent Morcell has passed on that information to everybody else who's responding. He is not required to tell every single law enforcement member every single thing that happened to him that day. He assumes that they already know because he already reported it, and that is why they're there. During this encounter, sheriff's deputies have some communication with Mr. Kelly. They have some communication with Alan, Mr. Kelly, and they start to search this area east of the house. You've heard testimony from these deputies. They're searching this area east of the house. Border Patrol is traveling south. Everybody says, we're looking for Mr. Kelly. And Wanda said that he went south. And yet the sheriff's department are searching east of the house. Why are they searching east of the house? They say they're just looking for Mr. Kelly. It's because Wanda told them this is where we saw those people. And so they're searching east of the house to try to find evidence of the folks who Mr. and Mrs. Kelly described. They comb through that area. They go over the two fences. They spread out. They're looking for people. They're looking for weapons. They're looking for people who might be injured or who might be hiding. And they don't find anybody. They don't find anybody. Ultimately, they come back and they talk to Mr. Kelly and his wife. And Mr. Kelly and his wife say, this is the area where we saw people. Mr. Kelly tells them, I heard a shot. He hears a shot and he sees people running with backpacks and rifles. And law enforcement chooses not to go and look again. They don't think it's important. They don't think it's worth it to try to go see if they can find something else now that they have more information. They don't sit down with Mrs. Kelly. They don't tell her, slow down a minute. Let's walk through this one step at a time. Tell me what you saw. Tell me what you did. Tell me where you were. They don't do that with Mr. Kelly either. They don't bother to slow down and get the information. They describe Wanda as being upset. Castañeda, Deputy Castañeda, who talked to Wanda, said she seemed upset. She seemed confused. She was distraught by what was happening. And yet, nobody took the time to ask her to take a breath, to slow down. Let's talk through this. Same thing with Mr. Kelly. He's just had this encounter. Imagine you're sitting in your kitchen and you hear a shot and you see what's happening and all this happens. Your adrenaline goes up. Your whole body is on alert when something like this happens. And when law enforcement gets there, it's still sort of coming down. It's still kind of washing out of you. Under those circumstances, people can't be expected. People who are victims of crimes, like Mr. and Mrs. Kelly were that day, they can't be expected to fully and clearly, from beginning to end, articulate to law enforcement exactly what happened. Law enforcement is trained to deal with that. Law enforcement should recognize that and talk to someone. Talk me through it slowly. That's all they had to do. Nobody did that. And now the fact that Mr. Kelly made some omissions because he's in that state of fear and agitation and adrenaline and excitement, that's being held against him. And that shouldn't be held against him. That should be held against the officers who didn't properly recognize the situation, who didn't ask questions of witnesses. You heard the state argue this was an emergency call, lights and sirens, active shooter. Law enforcement was on high alert when they came to the scene. They had their rifles out, and yet they failed to recognize that Mr. and Mrs. Kelly might be in a state of emotional agitation, to put it mildly. They don't recognize that. They don't do a slow walkthrough of the information. They don't take their time. They don't even go do another search. And now we are left with questions. We do not know if Gabriel Quinn Butimea's body was there when law enforcement arrived. It's a question that's outstanding. We don't know the answer to it, and now we never will. Ultimately, law enforcement leaves, and later in the evening, Alan finds this body on his property. This is the second time this day that things have gone from normal and regular to high anxiety, high stress, extreme situation happening here. I've never discovered a dead body on my property. You folks probably haven't either. But who's to say how any of us is going to react when we come upon something like that? How are we supposed to feel? What are we supposed to think? What is an appropriate response to finding a dead person on your property? And imagine what must be going through this man's head. He knows what happened earlier. He knows what he saw. He knows what he did. He knows he fired shots up over the tree in front of his patio, and now he's stumbling upon a person, and he doesn't know what happened. But he's a smart man, and he can put two and two together. And any intelligent person who's in his situation, imagine being in a situation where you fired shots and you know you didn't shoot this person, but you know you fired shots. That is scary. Anybody in Alan's shoes is going to be thinking, oh my Lord, what are they going to think when I call this in? It's a terrifying scenario for Alan. What would a guilty person do? What would someone do who's come across this body and who thinks, I probably shot this guy? What would a guilty person do in Alan's shoes? Someone with a huge, expansive property, someone who knows law enforcement was already here and they left, someone who knows that's where I was standing when I fired these shots. A guilty person had every opportunity to cover this up, and he would have been able to do so effectively. He could have disposed of the weapon. He could have picked up the shell casings. He even could have disposed of the body on this property. He didn't even need to do that. He could have just picked up the weapon, hid it, buried it somewhere, buried the shell casing somewhere, and never made a phone call and just left on a trip for a while. That's all he had to do. That's all a guilty person had to do. That's not what Alan did. Alan, even though he's standing there and even though he knows this looks bad, I don't know what's going to happen, he does the right thing. And he does the right thing because it's the right thing. You can tell when he's having these phone calls. In the state, they pull up some excerpts and they read them in their tone of voice. I encourage you to review these phone calls and listen to Alan's tone of voice. Listen to his demeanor, hear what he's saying. Is this a person who knows that he's guilty and is trying to cover things up, but nevertheless is calling law enforcement, which is what the state wants you to think? Or is this a person who is completely scared and shell-shocked because he knows he didn't do this, but he knows that calling it in is the right thing to do? And he trusts that law enforcement is going to do the right thing. He trusts that they are going to listen to him. And so he calls it in. He calls the Border Patrol, the guy with the badge and the gun, the guy who he called earlier, the same guy who sent all the deputies out earlier and who sent Border Patrol out earlier. There's no possibility that Alan thinks the Border Patrol is going to sweep this under the rug. No possibility whatsoever that he thinks that. He's still in a distraught state. He still doesn't know how he feels. He's still communicating in a vague way to Agent Morcell because he is in shock. What's the appropriate response when you find a dead body on your property? Can anyone say, here's how you're supposed to act, and if you act differently, then that's wrong? People act in all sorts of ways when confronted with shocking and frightening scenarios. And Alan couldn't form the words. He called for help and he tried. He tried to communicate what he was finding, and he did. You cannot listen to these phone calls with, well, there aren't phone calls recorded with Border Patrol, unfortunately. You can't listen to the phone call that Alan has with the Sheriff's Department and conclude that he's not communicating that there is a dead body on his property. He makes it very clear with the words that he can call to mind in that moment, which is a terrible moment for Mr. Kelly. There's a lot made about the phrase animal or the use of the word animal. Agent Morcell testified that he used that word first. He asked Mr. Kelly, what is it, Mr. Kelly? You're not telling me what's going on. Is there an animal? And Mr. Kelly responded to him and said, well, as opposed to a vegetable or a mineral, if you know what I mean. He's clear. He's making himself clear. And then he does the same thing when he's on the phone call with the Sheriff's Department. Something that else goes to Mr. Kelly's mind when he's talking with the Sheriff's Department is the Sheriff's Department dispatcher tells him, you said you shot something. The dispatcher tells that to Mr. Kelly when he has never said anything like that. Again, imagine, how must somebody feel knowing I fired shots earlier? I know I didn't hit this person. Here's a dead body. Oh, I'm afraid to call this in, but I have to call it in. And then when dispatch talks to him, dispatch says, you said you shot something. That is terrifying. That is a terrifying mistake that dispatch made, and it's terrifying for Alan to hear that. That's all in his mind when law enforcement is responding to his property. That's also all in the minds of all of the law enforcement personnel who are going to this property. They are being told incorrectly that Alan stated he struck something or he shot something when Alan never made that statement. And it's nobody's fault. Alan's on the phone with Agent Morcell. Agent Morcell is on the phone with Agent Tercy. Agent Tercy is relaying that to Agent Layugan. Agent Layugan is relaying that out to the Sheriff's Department. So you have all of these layers of telephone. And of course, things get lost in translation. It's not necessarily anybody's fault, but it is a crucial, crucial defining factor in this case. The investigators go out there already believing that this guy has confessed. They already have their suspect before they arrive at the scene. When they're at the scene, Lopez, the first person who comes out, he talks to Alan. He finally records a conversation. And his recording shows that his report was wrong. This is a theme that comes up repeatedly in this case. Law enforcement documents statements, especially Alan's statements, especially Wanda's statements, incorrectly. We have 2 reports from the first call from 2 different officers who both at the same time talked to Mrs. Kelly. And they both say that she said 2 completely different things. None of these conversations are recorded. Documentation is unreliable. The conversations between Mr. Kelly and Agent Morcell, not recorded, unreliable documentation. Finally, when we have a recording, it's Lopez, first person on the scene. He records him. And Lopez documents that conversation incorrectly in his report as well. According to Lopez's report, he says to Mr. Kelly, "Do you know if you shot him?" And Mr. Kelly says, "I have no idea." That sounds pretty bad. Sounds like Mr. Kelly's admitting he might have shot this person. That is not what Mr. Kelly said. When you listen to Lopez's recording, the recording says, "Do you know who shot him?" And Mr. Kelly says, "I have no idea." Very, very different. The documentation of the statements made in this case is really concerning to anybody who's worried about law enforcement being objective. You have Omar Rodriguez, who gets out and stands near the body. He's looking at the body. He's got this in his mind, and he speculates about the angle of the shot, the same way that you heard the state speculate in their argument to you about the angle of the shot. He says this shot comes in here, goes out here. There's the house over there. Aha! The shot must have come from there. That's not what any of the experts say. The experts say you have no idea, based on this evidence, where this shot came from. And we're going to get to them in a minute. But the initial investigators feel very free to speculate. You have Sergeant Flores, who takes photographs of the body. There's no note that the backpack is unzipped. Nobody raises that as an issue in any reports. Nobody raises the issue about how the backpack's pulled up over this person's head. Nobody raises the issue about how the fanny pack buckle is broken and the fanny pack is lying next to this person. There are photographs, we can see those things, but nobody seemed concerned about that. Nobody seemed to think maybe there are other crimes that have taken place here besides the obvious crime of this person's been shot. Nobody ever considered that there was any other evidence of any other crimes. Sergeant Flores on the stand specifically said, "No, I didn't see any evidence of any crime. None." Amazing. It's amazing. Think more about the emotional aspect of this. These are human beings. Alan's a human being. Wanda's a human being. We're not robots. We all react differently in different situations. Alan's on scene. Nobody's talked to him. Still, nobody's asked him, "Walk me through what happened. Show me where you were." Nobody does that. And then they put handcuffs on him. And they put him into a police car. Imagine what he must be thinking in that moment. Imagine just that feeling of, oh my gosh, this is really real now. They're taking me away in handcuffs from my house. I don't know if I'm coming back. That's an unbelievable moment for anybody to have to go through. Imagine Wanda. She's been sitting in the back of a police car. They don't ask her what happened. They don't walk her through the scene. They don't ask her anything. They put her in the back of a police car. Wanda, a person who has obviously never done anything wrong, who's obviously the victim of a crime. They put her in a police car. They take her to the station. That's an arrest. They arrest Wanda. They don't have any reason to do that. And right before they drive away with her, she sees her husband walking past the car in handcuffs. How does she feel when she's being taken to this interview? How does Alan feel when he's being taken to this interview? Would it be reasonable to be scared? Of course it would be. Would it be reasonable to be really concerned now? Maybe I don't really trust these investigators. I'm in handcuffs when I called them. That's a big concern. This is what's going on emotionally when Alan and Wanda are interviewed by law enforcement. And again, there's no slow walkthrough. There's no show me on a map where this is. What did you do? Describe this to me. Wait, let me back you up a little bit. Tell me more about this. They don't do any of that. There's browbeating. There's tactics used to try to scare this man into confessing. Detective Einsa tells him, you shot this person. That's pretty scary, especially if you know you didn't shoot this person. There's, we're going to find that rifle and we're going to do ballistics. By the way, what's Alan's response to that? He says, you don't need a search warrant. I will show you where the rifle is. I will show you where the rifle is. This rifle that's supposedly not in its proper place, according to these guys. Alan says, I will show you where this rifle is. Detective Einsa says, no. Fair enough. Okay. Then we get to significant issues of words being changed. And this starts with Alan. He's in this interview with Detective Einsa, and watch it. Don't pick out a line here or there. Watch it. You have the whole interview. Look at the whole thing beginning to end. Listen to the context. Listen to the tone of voice, the body language. It's a whole. Don't pick out a line and decide what it says. Watch it. Repeatedly, Detective Einsa says, you shot this person. You shot at these people. Alan says, no, I never did that. The state talked about a part in that interview where he was asked, did you shoot? And he doesn't answer. Watch the interview. Detective Barba asks him, did you shoot? Alan pauses, and then Detective Einsa jumps in with a different question, and Alan answers that question. He never denies having shot his rifle, ever. He's asked, he says, yes, I shot this rifle. I shot it up. I shot it over. Detective Einsa says, at, over, same thing. Alan says, no, it's not the same thing. It's a different thing. And there's back and forth about that a lot. Alan obviously thinks at and over are two different things. Alan also repeatedly says, I never chased anybody. I never went after anybody. I don't know where you're getting that. Watch the interview. It's there. In spite of this, law enforcement essentially fabricates a confession. They write down on the booking form. That booking form is their statement of probable cause. Here's what happened. Subject, he was chasing people. He shot. He admitted he shot at multiple subjects. That was not true. Alan never said that. Law enforcement wasn't listening, and they didn't care. They already decided that he was guilty, and they were perfectly fine inventing words for him, words that were the opposite of what he said and putting those down as if he said them. There's a lot made about Wanda. The treatment of Wanda in this case was just disgraceful. They're trying to say that she's lying to protect her husband. She said 5 and then she said 2. They come up with these extremely nitpicked, not recorded, supposed inconsistent statements to say that she's lying. And I would just submit to you that if Wanda were lying about what happened in this case, all she would have to do would be to say, I saw these guys, he pointed a rifle at my husband. That's all she would have to say. She didn't say that because she didn't see. But if she wanted to lie about something to protect Alan, very easy for her to do. That's all she would have to say, and nobody could contradict her. She didn't do it. So confirmation bias is a big thing that runs through this case, and it's the tendency to interpret new information and new evidence to confirm pre-existing beliefs and conclusions. And that plays a very big role in this case too. They do this interview with Alan. They don't listen to the words he says. They make up new words and they arrest him. They don't wait until they can do ballistics. They don't wait until maybe they can find some witnesses. They don't wait until they can do forensic testing or any drone footage or anything. They don't wait. They just go straight for this guy. And every single thing that they do after that, they design to confirm the decision that they've already made. It's natural. Human beings, we like to confirm that we're right. It's really uncomfortable to say I might have made a mistake. Maybe I was wrong. And so when they get a phone call from somebody calling himself Miguel, who says he's related to the family, they don't question it. And then when it turns out that that's false, well, oh well. They're not concerned that people are coming forward making false statements about this case, even though apparently they've talked about it. I don't know. But it doesn't bother them. Then there's this person, Ramon, and he says something different. He comes forward under different circumstances too. Does anybody bother to analyze his statements? Does anybody bother to compare his statements against Miguel's statements or Mr. Kelly's statements? Does anybody bother to compare Ramon's statements to the physical evidence in this case? No, of course not. They don't need to. They have their guy. They have their conclusion. Then we get to Daniel. The state says he makes consistent statements. And remember, if you're inconsistent, that means you might be lying about something. Well, Daniel doesn't even tell investigators what his name is in this case. He comes forward under very suspicious circumstances. He comes forward after this has all been out, after they know that Mr. Kelly's been arrested. His picture's been all over the place. Their version of events is out there for anyone to read, for anybody to think about, for anybody to make something up about. And here comes Daniel. And he lies about his name because he doesn't want to get deported back to Honduras. And he lies about his criminal history. He's asked, have you ever smuggled drugs in the United States? He says no. That is not true. He's telling a lie. The state says he's not associated with any criminal organization. He's not a drug smuggler. Daniel says, I'm not a drug smuggler. Well, except for when he is, because he took a plea in federal court under oath to smuggling drugs. Lied about his name to federal court also, by the way. You hear from law enforcement that you can't just accept a statement as the truth just because it's a statement. You have to test its credibility. You have to see if it matches up with other statements, with physical evidence, with known facts of the case, with forensic evidence. And that's how you can assess the reliability of a witness statement. I'm not going to get the whiteboard out again. You guys have seen me do it already, but you've got a body found 115 yards east of Mr. Kelly's house. You've got that body lying face down. You've got Daniel stating, we were 10 meters away from the house. We were to the west of the house. We were facing the border wall. Border wall is 2 football fields away. The shots were coming from over there, away from the house. That is impossible to believe. It could not have happened that way. We know for a fact, we're not guessing. We know for a fact that it did not happen the way that Daniel said that it happened. We know for a fact that Daniel previously told investigators he was 15 meters away from the border wall when this happened. We know that for a fact. State says he's consistent. How is that consistent? It's not. We know for a fact that Daniel claims he gets right up to that road that goes by the border wall where the pines are. I look back, I saw the person. We know that for a fact. We know that that is impossible. You all have been out there. You know what the end of the wall looks like. You know what this road looks like. That is impossible. We are not guessing about that. That is a fact. We know that the body's not on the west side of the house. Fact. We know that the body is not 10 yards away from the house. Fact. We know that there is no Border Patrol road that goes through this property that goes directly to the end of the wall, like Daniel said it did. Fact. We know he is wrong. What does that mean? It means he wasn't there. It means he is telling a story. Why? We don't know. But you can't be there and get it this wrong. It is not possible. I don't care if you have a 6th grade education. My kid has a 3rd grade education, and she can describe a place. It's not that hard. Nobody questions this either. Forget what Daniel says for a minute and how obviously false and concerning that is. What is wrong with the investigators in this case? Raul Rodriguez interviews Daniel, and he says things that Raul Rodriguez, Detective Rodriguez, admits these are not making sense. Instead of pursuing that, for example, he says this took place west of Nogales. No, it didn't. We know that for a fact. It took place east of Nogales. Instead of pursuing that as a possible problem, as a possible, maybe this person's not so credible, maybe they have another motive for coming forward, law enforcement doesn't bother asking any questions. Instead, they provide explanations. They provide help. They provide suggestion. They say, well, are you sure you were that close? That sounds pretty close. Are you sure? Well, maybe you don't know because you were running and maybe you were scared and so you didn't really know where you were, right? They make suggestive statements to this witness in an interview when really they should be suspicious about this and they should do some detective work to find out what the truth is, not to bolster what they've already decided they want the truth to be. That's not how an investigation should work. And let's remember, Daniel first comes forward because the sheriff goes into Mexico to meet with him. We don't have any good explanation for why the sheriff did that. There was a meeting that was arranged at the port that happened shortly after that. It's possible to do it that way. It's possible to do things the legal way. Why is the sheriff going into Mexico? Why? He doesn't wear a uniform because if you wear your uniform in Mexico, they get picky about that. That's what he said. It's quite the euphemism. And then they don't record this interview, and then they record part of it, and they've got no good reason for why they did that. That is sketchy. And that sets the tone for this whole investigation. So that's some of the facts, that's some of the evidence that you've heard from this witness. Let's talk about the forensics. The medical examiner's report essentially says there's no way to determine the time of death. This is a very significant fact in this case. What was the time of death? Because if his body wasn't there when the sheriff's department searched this area, then Alan has nothing to do with this. We have evidence that Omar Rodriguez examined the body. He says the torso is still warm. This is significant information. He could have passed that on to a medical examiner to get some sort of scientific determination of time of death. Didn't do that. They put the body in a cooler. They destroy any possibility of accurately determining a time of death scientifically. And the medical examiner's report proves that a gunshot wound is the cause of death. It doesn't prove which gun, doesn't prove which type of gun, doesn't prove which type of ammunition, doesn't prove even long gun or handgun, doesn't prove anything other than gunshot wound. Okay, great. The ballistics. Let's talk about that. See what can be proved in this case, what they did prove forensically. They talk about this as a long-range shot. I recall the ballistics experts testifying that what that means is this shot was fired from a distance of 6 feet away or further. That's a long range shot. So they've proven that this shot was taken from 6 feet away or further. Anything in between is a guess, and we are not supposed to guess. The ballistics, obviously there's no bullet, so they can't prove which weapon this came from. They can't prove which type of weapon this came from. They can't prove, again, which type of ammunition this came from. The shell casings, we heard testimony about shell casings that are found on the patio. They can't prove which direction the shooter was pointing. You make a circle around the shell casings. Shooter could be standing anywhere in that circle. They can't prove if the shooter was pointing straight or up or something else. Interestingly, the ballistics experts testified that had they been told that there was a possibility that this rifle was shot in an upward direction, they could have done testing on the shell casing pattern. And they might have been able to come to a conclusion about that. Yes, it was pointing up, or no, or it's inconclusive. But they didn't do the test because they were never asked to by the state. The investigators in this case never tested their own theory. They never considered that what Alan said might actually be supported by some evidence, and maybe we should look for that evidence too, not just evidence that shows that he's guilty. They didn't do that. And now we'll never know. Imagine if this were a sexual assault case and there was DNA of the perpetrator involved, and the investigators said, well, we could test that DNA, but it'll probably be inconclusive, so we're not going to test it. That's outrageous. That is outrageous. We have a right to expect that people who are investigating people for serious crimes are going to examine and test every piece of evidence that they can, even if it might not tell them something. What if it could? What if they did that test? What if it showed that an expert could say this rifle was pointed in an upward direction? It could do that. We would want to know that, wouldn't we? Before we decide what happened in this case. They didn't do it. The ballistics also, you've got this field of obstacles in between the porch and where this body is eventually located. You've seen the photographs, you've been to the scene, you know how many things are in between there. What I didn't hear the state address is the problem of the point of aim and the point of impact for this rifle. I'm not going to rehash all of that, but ballistics experts said that if that entry wound, and this is assuming the person's just standing there, we have no idea where this person was when he was shot. The ballistics experts testified that they could not possibly determine that based on the evidence that they saw. But the point of impact on this person was about 4 feet off the ground, which according to the experts means Alan would have to been aiming, if he took the shot, at a spot that's about 3 feet off the ground, which means he's aiming down. And you saw everything that was in the way. You saw the smoker, the pergola, the patio, the table and the chairs that's on there that's made out of cement. If he were firing in that manner, there would be evidence. The fact that there's no evidence of any bullet impacting anything in that entire field is evidence that supports what Alan said happened. If he fired where he said he fired, of course you don't expect to see bullet evidence in that field of obstacles, and you don't. The physical ballistics evidence is consistent with what Mr. Kelly said happened in this case.
Ms. Larkin,
Yes.
it's about 5 to noon. I think it's appropriate. It looks like you moving into a new area, so it's a good time to break. We'll take our noon recess. Same routine as we've been following all week long. We'll take a noon recess. You can go out to lunch. Please be back in the jury room at 1:30, at which time the defense will continue with its closing argument. We're in recess until 1:30 in the afternoon. Thank you.
Please rise.
All right, guys. Oh boy, we're getting so close. I'm going to end the video here. and go to work. I cut this so close. That's right. My boss loves me. Thank you so much for coming out. Thank you so much for watching. I really appreciate it. And I will see you next time. Bye, guys.
Got these life that goes digital dreams through the screen. Her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes mirror sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh